بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وقرة أعيننا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah. In our lessons on Imam Ibrahim al-Halabi's Multaqa al-Abhur, we have, by the grace of Allah, mighty and majestic, reached the 18th lesson on the fiqh al-mu'amalat, and this is details on kafala. And we'll begin also looking at Kitab al-Hawala bi-idhnillahi ta'ala. نسأل الله سبحانه وتعالى التوفيق والتسديد والثبات في المسير بإذن الله تعالى. And as we were mentioning, as we prepared to go live with you, that there are certain chapters that they may not have tons of practical application, but we benefit from them to understand principles. And principles not only related to the subject matter at hand, but also principles related to the subject itself, right? And that makes them of significance, bi'idhnillahi ta'ala. And they also highlight principles of the application of fiqh. So we have quite a bit to cover today. نسأل الله سبحانه وتعالى السداد والتسديد والتحقيق في المسير بفضله وكرمه. Okay, so and we will see some of these critical principles related to the methodology of the madhab as we tackle many of the issues today, bi'idhnillahi ta'ala. And today, we're going to look at details on the chapter of guarantee. We'll also look to understand the rulings of guarantors, guaranteeing for each other. Right? Because there may be a situation where one guarantor agrees to guarantee another, and what are the rulings related to that. Partners guaranteeing for one another, and also understanding what happens with debt transfer, hawala. We're going to take that as an addendum to this class, bi'idhnillahi ta'ala, and whose approval is required for a debt transfer, and to learn the two cases where the transferring debtor will be liable for the debt or not liable for the debt. We'll also, bi'idhnillahi ta'ala, look at rulings revolving compensation and claims, and seek to gain clarity on the ruling of the traveler giving a loan to receive at his destination and other related repercussions. This is called a suftuja or a saftuja, or it's said in several ways because it's originally from a term in Persian, and we'll seek to understand the principles related to that. Now, here, if we look in the first part, there are certain types of guarantees that are permissible, right? And that's the last part of the previous section. Bismillahir Rahmanir Rahim. قال الإمام إبراهيم الحلبي رحمة الله تعالى عليه ونفعنا به وبكم. وتجوز بالأعيان المضمونة بنفسها. So kafala is valid with items that are in of themselves indemnified. Items that are indemnified by their own value, such that if they perish, compensation is due. Right? Compensation is due. Right? Why? If you guarantee that if anything happens to this, I will pay. But if that item that you are guaranteeing, if it perishes without compensation, does the meaning of kafala apply there? No. Right? Because it's ضم ذمة إلى ذمة في المطالبة. And the mutalaba in kafala bil mal is المطالبة ماذا؟ بالمال, with either debt or the compensation is due if something perishes. Right? But in some cases, like in a sales contract, we looked at this, right? That if you guarantee that, okay, I'll get you your money back if the item of sale perishes. Can you guarantee that, Sadati?
Yes.
Did we take that from, where does it say that in the text, Sadati? Right? Like the bay'ah. What happened? Can you guarantee in the sale? What's the nas in the text? Right? Because what happens if the item of sale perishes? What happens to the sale?
Becomes battle.
Yeah, it becomes batil, right? We took, right? ولا تجوز الكفالة بما with a number of things منها بالأعيان المضمونة بغيرها. So in the case of a sale of a specific item, right? A piece of calligraphy, for example, right? A unique piece of calligraphy. If the sale was made but the item was not yet delivered, what happens to the sale? The sale itself is cancelled. So there's nothing to guarantee. Okay, so we took that. That's madmoon bighayrihi, and that section you can review. We don't want to spend a lot of time. But now there's certain things, certain a'yan, which if they perish, they're madmoon. What are those? That's what he takes here. كالمقبوض على سوم الشراء, right? Such as something for that the buyer took possession of in order to purchase. And this is al-maqbud على سوم الشراء. There are two conditions for al-maqbud على سوم الشراء. If we want to remind ourselves, what are the two conditions for al-maqbud على سوم الشراء? Sidi Abdul Latif? Al-maqbud على سوم الشراء, there are two key conditions, right? So al-maqbud على سوم الشراء, we took this, Sadati, which is when you have the buyer, the mushtari is considering the item to purchase. And this is sawm al-shira. Tasawum is when you're negotiating. Now for the purpose of purchase, sawm musawama is negotiation. So now you take qabd of it. You look at it. These are earphones. So I take it for the consideration of purchase. There are two conditions. What are they?
Consider buying and the price is known.
Yeah, right. So this is when you asked for the item in the context of negotiation, and you've asked about the price, right? And we had given some readings about it before. We explained it earlier, so we're not going to take a lot of time. So al-maqbud ala sawm al-shira, if it perishes, what is due?
الثمن.
تجب القيمة, right? Right? تجب القيمة, right? The market value is due. Okay. So that would be, you could make a guarantee of that. Someone wants to inspect a fine piece of calligraphy. And Uncle Latif knows that Uncle Masir, and this is not Sidi Masir, so I'm not backbiting you, Sidi Masir, but Uncle Masir, or we can call Uncle Munir, is a little bit clumsy. So Uncle Latif says, sorry, I'm not going to let you handle the piece of calligraphy. He said, but I want to buy it. So someone comes in and they say, okay, I will guarantee it if something happens. You can do it, because if it perishes, it's madmoon, right? There's liability for it. Likewise, wal-maghsoob, right? Wal-maghsoob, wal-mabi'u fasidan, right? So the maghsoob, the surat al-mas'ala, right, is that if you misappropriate someone's property, what becomes due? right? There's liability for it, right? You don't just buy it, but if anything, if it perishes, the qima is due. So there are various scenarios of it. One would be that if someone says, okay, look, someone's borrowing something and you say, if he refuses to return it, I'm his guarantor, right? Because when you borrow something, right? When you borrow something and then refuse to return it, then it goes from being a borrowing to becoming a misappropriation. It's very important to understand. I just borrowed it, but if the person's asking for it back and you refuse, your yad goes from being yad of amanat to being a yad of daman. You're liable and culpable. Is that wadih, Saadati? Because it's an important concept. Right?
Yes.
That, if you borrow something, i'ara, and then they're asking for it back, and you say, no, I can't give it back right now. I'm having a party on Saturday. I need this table. The person says, no, I want it. Said, I'm sorry, I can't give it back to you. Then if something happens to it, this was ghasb. But if, let's say, Ibrahim was reluctant to lend something to someone, and her friend, can Ibrahim, can your friend guarantee that the person will give it back to you? Is that a valid, that if anything happens to what your friend, Munira, is borrowing, if anything happens to the item borrowed, I'm the guarantor. Is that a valid kafala? For mere borrowing. Yeah, for mere borrowing, no, it isn't. Why? Because the yad of the one borrowing is a yad of amana. Good. Jazakallah khair. But what you can make a conditional guarantee, right? That if the person, if after you request the item back, if they refuse to give it back, then I guarantee it. Because then it becomes ghasb. Right? Because yad of the makhsoob is a yad of what? Yad of Sadati. The makhsoob, the one who misappropriates something, their yad is yadu
Daman.
daman. Good. It's a yadu daman. Very good. Right? So this is wal makhsoob, that item that is misappropriated. One of the ways it could realistically happen, there's many suwar of the mas'ala, is if someone misappropriates, or let's say if someone gangs up, that, Uncle Masir is a gangster. So someone misappropriated they just took their table without permission. So I'm going to go beat him up. And I'm getting, so no, look, let me go talk to him. And if he doesn't give it, I am his guarantor. Okay? Because sometimes people use the law of the jungle. So a wise man comes in, a wise lady comes in and says, look, if anything happens to it, I am the guarantor. Please don't go beat up Uncle Masir. He's an old man. Or whoever the case is. So this is the multiple suwar of وَالْمَبِيعُ فَاسِدًا. Right? وَالْمَبِيعُ فَاسِدًا, because the mabi' in the bay' al-fasid, what is due for it? إذا هلك المبيع في البيع الفاسد ما الذي يجب؟ So the item is, someone sold, Zubair sold his wife Zubaydah these earphones because she lost hers. But they didn't set a price. So bay' fasid. But then she lost this one as well. What is due on it? The qima.
Qima.
Right? The qima. Right? Because they didn't set a price. Zubayr said, Zubaydah, I sell you these earphones. She said, I accept. They didn't set a price. Then she lost these ones too. So the qima is due. But then she lost the ones she sold as well. So you can't cancel the sale because it perished. So then the qima, the market value, would be due. So you could be a guarantor, right? So Zubayr wants to go divorce Zubaydah. So his family member, Ibrahim, goes and said, Zubayr bhai, please don't divorce her. If she doesn't pay for it, I'll cover it. I'm the guarantee. I'll guarantee it. Give me a month. I said, okay. So that's the Surah Al-Masala. I hope it's clear. وكذا تجوز الكفالة. Likewise, it is valid to make kafala بتسليم like this واو here. We should parse these sentences ourselves. وكذا تصح الكفالة بتسليم المبيع إلى المشتري. Right? That the item will be delivered to the seller. Right? بتسليم المبيع إلى المشتري والمرهون إلى الراهن. And likewise the item that of collateral to to the depositor. والمستأجر إلى المستأجر. And the item rented to the one renting. So you could guarantee that. Right? Because let's say payment is expected in advance, but how do I know you'll drop off the car? So someone says, look, if they don't, I am the guarantor, so you'll get your money back. تماما. وبالثمن. Right? Right? And likewise with the price, right? That is sort of an addendum, right? With the thaman, right? That, which is in the case, the thaman, who would you be guaranteeing this for?
The buyer?
No, but who is owed the thaman?
The seller.
Who's owed? The seller, yeah. Right? That, who is this young guy who wants to buy this piece of calligraphy? He said, look, if he doesn't pay, I'm his guarantor. You can just say, I'm his guarantor, full stop. So, okay, then pay me now, right? Or you can say, if he doesn't pay, I will pay. But either way, all the rulings apply in this. Okay. So this is the leftover part. One of the reasons I left it, frankly, I ran out of energy and we were late, but also because this reiterates the principles that we took before. And you could diagram what are al-a'yan al-madmunatu binafsiha bighayriha. Kafala is not valid in them. You should make a list of those and why. And we took them. And al-a'yan al-madmunatu binafsiha. And these are some examples. The thaman is the most important one. But al-maqbood ala sawm al-shira is also important. But al-maqbood ala sawm al-shira, it also has an important aspect that diyanatan. If you are looking at something, so you go to Istanbul and you're looking at a piece of calligraphy and you'd asked about the price, you're looking at it and checking this way, that, and you drop it and it breaks. The guy hasn't asked you for anything out of it. But diyanatan, if you know your deen, what are you expected to do?
Compensate for it.
Yeah, compensate for it, right? Compensate for it because the qima, the market value, is due, right? And diyanatan, even if they didn't ask you for it, right? Because they may have haya, etc. And these things then lead to dispute. تماما. نسأل الله اللطف والعافية والفقه في الدين. That's why Abu Hanifa's definition of fiqh is الفقه معرفة النفس ما لها وما عليها. Fiqh is to know oneself, what is for you and against you. And what is for you and against you, ما لها, right? One has to do is that ما يجب عليها ما لها, right? That what are your rights? وما عليها من حقوق. ما لها من حقوق وما عليها من واجبات. ما لها من الثواب وما عليها من العقاب. Right? In terms of what is for you of reward if you make the right choice, and what is against you of punishment if you don't. And there are several other tafasir of this statement. Inshallah, if you want to look for it, look for a few and share on the forum. And you make a note that this is one of the things we've covered in this lesson. That will be, inshallah, of benefit. Tamaman. Allahumma salli ala Sayyidina Muhammad. Then we look on details on guarantees. We're going to go reasonably fast on this because a lot of it's... so these are the same. One of the things we're going to look at is the issue of bay' al-'ina. We're also going to look at the dhaman al-darak, bi'idhnillah, as two of the critical, all the important things. So he says, وَلَوْ دَفَعَ الْأَصِيلَ الْمَالَ إلى كفيله قبل دفع الكفيل إلى الطالب لا يسترده منه. If the debtor gives the guarantor before the creditor is paid, he cannot demand the return of it. Okay? Because this money, it becomes an amana, that what does the kafil do with it? What's the kafil morally bound to do with it?
Give it to the talib.
Yeah, give it to the one owed. But it becomes an amana with him, right? It becomes an amana with him. Okay. But then he can't ask for it back. وَمَا رَبِحَ فِيهِ الْكَفِيلِ فَلَهُ. But that money that was given to the kafil, it becomes his in a sense, but he can't, if he then used it, it belongs to him. Why would he use it? Because this mal لا يتعين. This money given does not become muta'ayyin. It doesn't become specified. Okay. Doesn't become specified. Right? There's some money that if you take, your yad in it is amana, and it becomes specified regarding that money itself. Right? So one needs to be careful. And then the fuqaha mentioned this here and there. So certain things that, for example, if someone gives you an envelope with $5,000 and said, give this, in general, if someone gives you money and they give it to give someone else, and it's done in this way. So pay attention to this, right? Someone, like if you're traveling to Cairo, and someone says, okay, give this $5,000 to Uncle Tariq. Are you allowed to use that and give other $5,000 to Uncle Tariq? No, you're not, right? Because that money becomes muta'ayyan. If you don't want to do that, that's okay. Then you have to clarify. But here he just gave dafa al-mal. He just gave money to him, right? Then that does not become specified, It enters the ownership of the kafil, and all the kafil now has to do is to pay the asil, and the one owed the money. So pay attention to these two different suwar, inshallah. Nasallahu subhanahu wa ta'ala al-lutf wa taysir, right? So given that it's his, if there's any ribh, it belongs to him. وَلَا يَتَصَدَّقْ بِهِ. And because it's his, لَا يَتَصَدَّقْ بِهِ. Because this money enters his milk. He said, here's $1,000, right? And please remember to pay the other person. Okay. So this is a different surah, but he says, give this money, but if he specifies it further, it will become specified. Give this money to the asil, then it's not permissible. And you can, quite a lot of discussion here. But because of the similarity between the two issues, he says, وَرَدُّهُ إِلَى الْمَطْلُوبِ أَحَبُّ إِنْ كَانَ الْمَدْفُوعِ شَيْئًا يَتَعَيَّنُ كَالْبُرِّ خِلَافًا لَهُمَا. Right? And returning the profit to, returning رَدُّهُ رَدُّ الرِّبْحِ إِلَى الْمَطْلُوبِ. The matlub being the one who owes the money is better if it is something that is specific, right? Like wheat, for example, right? So what was owed was wheat. He said, take this wheat, right? Take this 1,000 kilos of wheat. And it's understood that that's to be given to the other person. The person sold this wheat, and when he goes to pay, he'll pay the other person. So that would be better. Okay. And he says, خلافا لهما, as opposed to the Sahibain. And then now we have بيع العينة. Right? So he says, ولو أمر الأصيل كفيله أن يتعين عليه ثوبا ففعل والثوب للكفيل فالثوب للكفيل والربح عليه. Right? So to understand this, we first have to understand بيع العينة and what it is. And then to understand the ruling of بيع العينة, so the scenario here is if the asil, yeah, who's the asil?
The
So that
matlub,
who's
the one
the
being
asil?
guaranteed
Original
for.
debtor.
So is he the one who owes the money or the one who's owed the money?
Owes the money.
Okay. So لو أمر الأصيل, right, كفيله, the guarantor, and يعين عليه, right? So بيع العينة is to buy something as a loophole for riba. Why would this arise in a debt? So arise in a debt because let's say the person who is owed the money, right, realizes that, okay, you're not going to be able to pay on time. Right, so you owe $1,000 that was due today. So the one who owes the money needs more time. So now the guarantor is involved too. So the one who's owed the money, if they do this, right? So what do they want? That can you extend, firstly, to understand riba. If the one owed the money says, look, listen, I'll give you 2 more years to pay, but you have to add $200 to the price, to the debt. Is that allowed?
No.
No, because what is that? That's riba. So the way to avoid riba, quote unquote, like as a hila, is, right, is that you bring in an item in the middle in this way, right? You bring in an item, so you make a sale, so the debt is owed, right? The calligraphy piece was for $1,000 due today, which is a year later, $1,000 is due. But you can't pay, you need another year. This is okay. But the seller doesn't want explicit riba, so he says, look, and there's a guarantor involved, right? So what does he say? He says, okay, I will agree to delay the debt, but let's come to an agreement on the side. What's the agreement on the side? The agreement on the side is that let's engage in the sale of an item of clothing, a thobe, for example, right? That through it, we create an extra debt. Who would the debt be owed to? the debt would be owed to the money, the original money is due to, right? Because ultimately he was owed 1,000 to defer the original debt was for the fine piece of calligraphy. He was owed 1,000. To get the extra time, he wants 200 more. But he says, okay, let's engineer the sale of these few carpets, prayer carpets. From that, we want to create another debt of $200. Right? So you buy the carpets for you buy the carpets for 500 and sell them for 700 due later. So what have you just created? Another $200 of debt. Another $200 of debt. But then by involving the carpets or the thobe, the cloth, in there, you have avoided suratan riba. Okay, you have avoided the surah of riba. So this is bay' al-'ina. So if this is done with the kafil, right? So amara al-asil kafilahu an yu'ayyana alayhi thawban fafa'al fathawbu lil-kafil. So the thawb is for the kafil. Wa-ribhu alayhi. And who owes this profit, the profit from this engineering, is owed by the guarantor, right? Because this is separate from the original transaction, right? And the definition given by Maulana al-Haskafi is هذا يسمى بيع العينة. This is called بيع العينة. أي بيع العين بربح نسيئة, selling an item with profit that is deferred in order ليبيعها المستقرض, in order that the one who has given the debt sell it for less ليقضي دينه, to clear their debt. اخترعه أكلة الربا, those who consume riba have made this, and he says هو مكروه, and it's disliked, أي مكروه تحريما. اخترعه أكلة الربا ومكروه ومذموم شرعا, and it is highly despicable. Why is it highly despicable? Because it is a hila for riba. Okay, and right. So before we look at the hadith, if you look in Shaykh Zada, he gives a very nice explanation as well. And we encourage you to follow along with, Majma' al-Anhur and the other commentary. But in Majma' al-Anhur, he says, بيانه, this مسألة, أن الأصيل أمر الكفيل بأن يشتري له ثوبا. The أصيل commanded the kafil to buy cloth for him. بأكثر من القيمة. This is just one of the suwar. There are many forms. For more than the price. So it's worth 500. He buys it for 700. ليقضي به دينه بطريق العينة. To clear his debt through عينة. And he gives several examples. You can read them. Would someone volunteer to? There's 3 examples given. If someone could give the text of the examples in Arabic in one column and in another column, give the examples in English. He gives several examples, right? Anyone volunteer to do that? Okay. And now the hadith of the Prophet ﷺ, there's many hadiths about it. The Prophet ﷺ talked about the fasad al-zaman, right? And he mentioned a number of things that would be a source of dhul for the ummah and for whoever engages in it specifically, whenever they engage in it. So he had said, alayhi salatu wasalam, إِذَا تَبَايَعْتُمْ بِالْعِينَ, if you buy and sell through عِينَ contracts, right? Which is through ways where you falsely create debt, as a loophole to riba, right? And the other aspect, وَأَخَذْتُمْ أَذْنَابَ الْبَقَرِ, and you cut the ears of camels, and there's a number of possible interpretations of what that means. وَرَضِيتُمْ بِالزَّرَعِ, and you are content merely with agriculture. And again, this hadith, like many of the hadith of ashrat, right, and warning, they have many possible interpretations. One of which is إِذَا رَضِيتُمْ الزِّرَاعَ. If you look in the hadith commentaries, one of them is that إِذَا رَضِيتُمْ الزِّرَاعَ, if you're content merely with farming, one is that and you avoid and you do not engage in jihad. And you do not engage in jihad when you have to. Another is that you become content with the life of this dunya and just gaining wealth, right? So you just become a landowner and you do not fulfill the furudul kifaya yourself nor participate in them, right? Because the believer has personal duties and they have public duties, like we know from Surah Al-Asr and other. So those are two of the jihad, just general inclination towards the dunya. Number 3 is not fulfilling the furudul kifaya, right, directly or through concern for them and support of them. وَتَرَكْتُمُ الْجِهَادِ, and this waw is either for tanawwur, right, that this is like it's a list of things, right? It's a list of things, or the other is the waw is lil hal, right? The waw lil hal, that if you do these other things, right, that if you go in Eena and you cut the ears of cattle and you're content just with agriculture, right, meaning contentness with dunya and neglect of duties, and you leave jihad, so this is either a list or حال ترككم الجهاد, right, that if you engage in these things while also leaving jihad, سلط الله عليكم ذلا لا ينزعه حتى ترجعوا إلى دينكم. Allah will impose upon you a dhul, an abasement that He will not lift until you return to your deen. Right? Right? And this hadith is related by Imam Abu Dawood and others. And there are multiple such narrations on Bay' al-Ina. Right? So Bay' al-Ina is makruh tahriman. Right? So when they say karaha when it's mentioned in matters related to the halal and haram, it is understood to be okay. So karaha, when it's related to the halal and haram, it's understood to refer to what? Karaha tahrim. It is very important to understand, but when we convey such things, we explain that we don't just say karaha, it's sinful and prohibitively disliked, because people don't understand that karaha is just disliked, it's kind of better to avoid. So it's said that Imam Abu Yusuf did not dislike it, and how that is understood is and there are similar other things that Abu Yusuf did not dislike, and some ulama said that this is less bad than other things that people do in the marketplace, right? Because which is outright haram, is that in general the hiyal have two circumstances. The hila has two circumstances. There are hila that is done in a situation of need. In a situation of need. That let's say that Uncle Bilal got sick and he owes money to Uncle Jamil. So Bilal owes this money, and Uncle Jamil, if he doesn't pay back, he's a thug. You're going to send some thugs and break his bones, and smash his property, etc. So he has to pay. So he can either use a loophole. Or he can engage in outright riba. So which is less bad in a situation of need? Engaging in outright riba or engaging in a loophole?
The loophole.
The loophole, right? So that's what's considered permissible in terms of loopholes, and where we understand where they say la ba'sa bil hila, right? Or several statements related to Imam Abu Yusuf, right? Even with respect to zakat. Many of you claim to have studied Nur al-Idah and Maraq al-Falah. What is the position mentioned from Abu Yusuf with respect to hilat al-zakat? Anyone? And it comes up even in the Multaqa, Sadati. What does he say? That there's nothing wrong with the hilat al-zakah. It's your money. If you want to protect it, it's your right. But this would be in situations where, like, you take a loophole to avoid an excessive burden of zakat on you. In a situation, someone didn't know that you have to pay zakat on inventory. So just before the zakat is due, he says, oh my goodness, if I keep all this as inventory, I have to pay 2.5% of a huge amount, and he took on a huge amount of inventory unthinkingly. So, right? So it'd be in summary, but of course this requires fatwa. You can't just give yourself a fatwa. Using a loophole in a situation of need, right? To take one from strong disadvantage or hardship would be allowed. Right? It would be, as Ibrahim says, it would be the lesser harm, number one. And number two, it would be حفظ مال الشخص, right? The person preserving their wealth when there's a need, or to prevent, but there's a difference between that, and we can conceptually understand the difference between that and us setting up contracts. So, right? Bilal Islamic Bank, BIB, right? What does it do? It sets up a whole number of hiyal of riba, right? Of just loopholes against riba that substantially are just loopholes. That would be blameworthy. That would be blameworthy, and it would not be allowed. Or if this spreads in society, that the only way people facilitate financing, etc., would be through loopholes, that would be a problem, right? And this is a tension in modern Islamic finance. A tension in modern Islamic finance where, how do we facilitate financing? Because ultimately, is there a similarity between permissible financing and impermissible financing? Sadati? Yes. And that's the objection of the mushrikeen, right? إِنَّمَا الْبَيْعُ مِثْلُ الرِّبَى. That trade is like riba. But أَحَلَّ اللَّهُ الْبَيْعَ. There's certain core fundamental characteristics of trade, right? Trade, investment, and profit that Allah has permitted out of His wisdom. And وَحَرَّمَ الرِّبَى. And He has prohibited riba. So here, how do we determine what is a loophole and what is a sound permissible contract? How would we figure out the difference between the two? As a common person, what is their duty in nuanced matters?
Avoid or ask a scholar.
Yeah. فَاسْأَلُوا أَهْلَ الذِّكْرِ إِن كُنتُمْ لَا تَعْلَمُونَ. Ask the people of remembrance if you know not. And the duty of the people of remembrance would to make clear why, how and why this is trade and how and why this is riba. Because the duty of Ahl al-Ilm is al-Bayan. Al-Bayan. And for a Talib Ilm, our duty is not just to learn, okay, this has been permitted according to AOFI standards, according to this, but to understand the underlying principles. Right? So number one, does taqleed entail that we just follow whatever our teacher says?
No.
No. Right? So like if I make a mistake, do you just say, okay, well, according to Shaykh Faraz, this is what it says? Is that fulfilling your duty as a Talib Ilm?
No.
No, right? And if you're a Talib Ilm at an intermediate level, an advanced level, any level, even at a basic thing, if the sermon says that, okay, if you prayed without your pants on, your prayer is valid. And someone could just be a slip of the tongue. What's your duty in that class?
To remind.
Yeah, to remind. You have good husn dhan, maybe the person, maybe it's a slip of the tongue, maybe they're tired. You have husn dhan, but we do what is right, right? من عرف الحق بالرجال تحير في متاهات الضلال. As Imam al-Ghazali says in the Book of Knowledge, whoever determines truth by just what people say will be bewildered in the plains of confusion. فَعْرِفِ الْحَقِّ تَعْرِفْ رِجَالَهُ. So know the truth and you know its people. So that is very, very important. So in things like this, yes, it may seem sometimes that certain solutions, is this not just a hila? When it comes to issues in Islamic finance, etc. So the answer is that one, we have to ask the ulama. And then we also have to realize that sometimes change, like in life in general, change does not happen immediately. Change does not happen immediately. Sometimes necessarily change takes time. Right? Change takes time. So the ulama on certain things, they have allowed some things that are not outright riba. Yes, this may be something of a hila. Why? Because there is an ummatic interest in getting out of outright riba. Right? But what is the goal? What's supposed to be the goal in Islamic finance is to go out of a ribawi system into a system that is clear from riba. But often it's difficult because one's swimming against the current, but one has to realize that there's a tension in this. I was with the Mufti, and he's a God-fearing man and a learned alim of a particular the Grand Mufti of a particular country, and he said, you know what I tell the banker, the Islamic bankers, he said, I tell them that, look, while we give fatwa that it is permissible to deal with you guys and that they have no excuse to go to a conventional bank for financing, given that you guys are here, he said, but if there were other alternatives to you guys, I would give fatwa that you're not allowed. Because of because bankers, even Islamic bankers, they want to use loopholes. The ulama are holding them back, and this is, right? And this is, this is a tension that as you study this field, etc., you need to be aware of. But that's why, inshallah, as you progress in fiqh al-mu'amalat, to be aware that the ulama of understanding, they do not view the status quo with respect to Islamic banking or the present scenario with respect to Islamic banking, even things like the AOFI standards, AAOIFI standards, as being the be-all and end-all of the Islamic financial alternative. Right? That given that they are functional, non-ribawi models, then you do not have any excuse for riba, even if there's no alternative. Right? It's أشد المحرمات بعد الإشراك بالله. It's the most intensely prohibited matters after associating partners with Allah. Right? But then there are hiyal of riba that are less bad, but if done without need, if done in a widespread way, or if institutionalized, they are akin to riba. Right? So yes. So this is and there's a tension related to this between the ulama in this, but so the advice would be tullab ilm as you pursue this. Don't just rush to become just practitioners. That, well, I'm learning fiqh al-mu'amalat and then what, the fiqh of Islamic finance just to get a job, because that's dunya, right? And the talab al-ilm is not for dunya. Talab al-ahkam al-shar'iyya, it is ubudiyatan lillahi ta'ala. Qiyaman bifard al-ayn wa fard al-kifaya. Inshallah, that's clear. I wanted to make this because this issue of loopholes is very, very important. Tamaman sadati. So that is related to Bay' al-Ina. And Sidi Abdul Latif, do remind, we will share some details related to this. So if this happens, right? So the summary of this issue, right? The masala itself there of the Bay' al-Ina before is that in that scenario, what happens is that the bay'ah is that the thob belongs to the kafil and the profit belongs to him, right? So we ask Allah subhanahu wa ta'ala to grant us clarity in this, right? That if in this scenario, right, فَالثَّوْبُ لِلْكَفِيلِ وَالرِّبْحُ عَلَيْهِ, right? So he's the one who owes this. So if this was done, because this is a second contract that was engaged in, and who engaged in the Bay' al-Ina contract? The kafil, right? So the one who requested this does not own anything. Okay. And then moving on to a separate issue, he says rahimahullah ta'ala, وَمَنْ كَفَلَ لِآخَرَ بِمَا ذَابَ عَلَيْهِ مَا ذَابَ أي مَا وَجَبَ عَلَيْهِ. Right? ذَابَ is for something to unfold, right? That's why ذَوْب is like when the ice melts, what was below it becomes manifest, right? That which ensues, right? That which ensues. The consequence of something. So من كفل لآخر بما ذاب له على غريمه أو بما قضى له به عليه فغاب الغريم فبرهن الطالب على الكفيل بأنه على الغريم ألفا لا يقبل. Right? So the scenario here is that whoever guarantees for another, that they will guarantee that which arises against them, right? In the transaction, right? With ala gharimihi, right? With respect to the gharim. Who's the gharim, Sadati? Who is the gharim? So the fa'il, what is it used for? Ghurm is what is owed. Right? What is owed. So the gharim is the one who owes. Right? Right? The one who owes. Yani, that بِمَا ذَابَ لَهُ عَلَى غَرِيمِهِ. So someone became a guarantor for the person owed the money. واضح? مَنْ كَفَلَ لِآخَرْ بِمَا ذَابَ لَهُ عَلَى غَرِيمِهِ. That anything that this person who owes money, it appears that they owed, because they're paying installments, but they sometimes get delayed, this, that. So, okay, I will guarantee what this person ends up owing you. This is valid, number one, right? أو بما قضي له به عليه. Or if it goes to court, if qada is made with respect to this, فغاب الغريم. So the one who owes the money disappears. And Sadati, please look up these terms, right? Gharim, what does it refer to? Gharim, what is ghurm? Right? There are two terms, right? Al-ghurm, and what is related to ghurm? And there's a qaida related to al-ghunmu bil-ghurm. Right? Benefits, ghunm, with a noon, ghunm, ghanima is grain. Ghurm, with a ra, is gains come with dues. Right? Benefits come with costs. Right? So, اغتنم is benefit. اغتنم خمسا قبل خمس. And ghurm is what you owe. Right? So the gharim, the gharim is the one who owes. واضح? Alhamdulillah. Okay. تماما. So this happens, right? He takes on, okay, and whatever in court, he owes you in court, the gharim owes you in court, I will, I'm the guarantor for it. فغاب الغريم. He's a real loser, right? Or it's in trouble. Let's not judge the anonymous guy, but appears that he's a bit of a problem case, right? He disappears. غاب الغريم, right? We don't know where he is. So, but the one owed the money wants the money. فبرهن الطالب على الكفيل. So the talib, who's the talib? The one owed the money, provides evidence against the kafil بأن له للطالب على الغريم ألفا, that the gharim owes 1,000. لا يقبل. Right? This is not accepted. And the reason it is not accepted, that in general, shahada ala al-ghaib is not valid. In general, shahada ala al-ghaib is not accepted. Why? Why is shahada against the ghaib not accepted? Well, there's evidence related to that, but also for a simple reason. That, okay, the one who owes the money, who's the one who is owed the money, in this case, the one who's referred to as the talib, they have proof. But who else may have proof?
The one being testified against.
Yeah, the one being testified against ultimately, right? The gharim. Right? The gharim. Is there not a possibility that the gharim, before they traveled, had paid the debt? But it's undocumented. Last thing he did before he went to Hajj is that he went to Uncle Masir, not Sidi Masir, Uncle Masir, and said, Uncle Masir, I'm on the way to the airport, but I owe you 1,000. Here, I'm giving you 500. But they didn't document it. Is it a sin not to document it? Is it sinful not to document a transaction? No, right? It's khilaf al-mustahab. Anything of material significance should be documented. But its hukum shar'i is al-istihbab. واضح? Right? It's recommended. So in this scenario, right? So in general, there are exceptions, but in general, ash-shahada ala al-ghaib is not allowed. And there's many other possibilities why, but this is one. So this is not accepted, meaning until the gharim appears. لا تقبل. Right? And then, what? ولو برهن أن له على زيد ألفا وهذا كفيله بأمره قضي به عليهما. Right? So if he can prove, right, if the one owed money, ولو برهن الطالب, right, the one who's owed the money, أن له على زيد, right, this is the مطلوب, ألفا, وهذا كفيله, أي وبرهن أن هذا كفيله, right, بأمره, with the amr of the one owed money, who in this case is Zayd, قضي به أي بالألف عليهما للكفيل, right? يعني فالكفيل, but in this case the kafil would have the right of going back to the one who owes the money with the money owed. واضح؟ ولو بلا أمره قضي على الكفيل فقط. But if the kafil took on the kafala without the amr of the one who owes the money originally, then, but he entered into the kafala. That's the danger of kafala. That Uncle Bilal is going to go beat up Zaid. In this case, if he hasn't paid, so he says, look, I will pay. So he goes in front of court, he agrees to pay, etc. And there's proof that he agreed to pay on behalf of Khalid. But Khalid says, look, I just can't pay right now. And I didn't agree for you to pay. And who are you? Uncle Masir, to pay my debt, etc. Right? So that's the same principle, right? That when there's a haqq of rujua, but if the one owed the money can prove that the kafil had taken on the guarantee, but there's no proof that it was on behalf of Zayd with Zayd's agreement, then the qada would be made that, look, O kafil, you owe the money that you guaranteed. Right? So the kafala is sensitive in this kind of regard. And then he says, وَضَمَانُ الدَّرَكِ لِلْمُشْتَرِي عند البيع تسليم يبطل دعوى الضامن المبيع بعد ذلك. So this is related to an issue called ضمان الدرك, and we'll complete this in the second part of the lesson بإذن الله تعالى. One can read up on ضمان الدرك, and if you would like to participate in this together, you can look up the definition of ضمان الدرك and the Surah al-Mas'ala. We will do a supplementary lesson just to cover this up, so we can catch up a little bit. So some of these don't have direct value, but we see that they do illustrate a lot of very important principles, right? They illustrate a lot of very important principles, right? So there's a number of types of dhaman that are not valid, and there's some types of dhaman that are valid. So we'll unpack them a little bit. But just, the key is but I'd like you to practice this as well, right? And I want to reiterate it before we look at it in full, is that you understand things first. You have to unpack the text to understand what's going on. Number one. Number two, you have to unpack the text. You have to understand the dhamir, etc., these terms, what is meant by ghareem, etc. And all of you, those of you who are following along, you are serious students, but this is how you have to do it. Like, you can't understand the masala if you're not sure what does ghareem mean. You got to look it up, right? To try to prepare and to give it its due. You have to unpack it in terms of language, that okay, unpack the dhamir soup, the mentioned dhamair and the implicit dhamair, right? You unpack those, and for that, the commentaries are useful to help unpack that, but also apply your language. Many of the ulama say that relying on the commentaries directly weakens your understanding. Why would that be? Relying on commentaries directly, like immediately, weakens your understanding. Why would that be?
Because it reduces your ability to extract or, understand the text yourself.
Yeah,
You
because
rely too much.
Yeah, because you have to apply the tools of learning, particularly what? Particularly nahu and sarf, like ghareem, right? Ghareem, how does it relate to sarf? Like the term ghareem, how does it relate to sarf? Because it's a form, right? Fa'il. How did we get to fa'il? What does fa'il indicate? What department of Arabic deals with this? Sarf, right? So you have to think, okay, fa'il, what does this indicate? Okay, so there's the root meaning, but fa'il, and we know fa'il is frequently used bima'na what? Bima'na fa'il. Okay, so I get that. Now, if I get that, then I can take the next step, which is, okay, parse it min hayth al-lugha. And that's an important discipline. And that's why the ulama wrote as they wrote. You know, and Shaykh Talal al-Ahdab, he once made a very, and Shaykh Talal al-Ahdab, who's now, who's in graduate studies at Zaytuna, one of the most remarkable Ahl ilm, and it's useful. If you want to listen to khutbahs that are sort of mind expanding, not necessarily very exciting, but they're very precise, very beneficial, very deep. And say, Abdul Latif, we can share that on the forum. MCC in the Bay Area has many khutbahs of Shaykh Talal al-Ahdab, AHDAB. So we can share that playlist, and inshallah we'll post it on Seekers would not exist without had it not been for Shaykh Talal al-Ahdab. He's one of the most remarkable scholars in the West, and someone to benefit from in any way that you're able to find. May Allah bless him and preserve him, one of our first teachers, and someone who remains a mentor, Hafidhahullah. But Shaykh Talal said something very important. He said, the ulama wrote on the understanding that the human being is a hayawanun aqil. And a lot of contemporary writing is on the basis that the human being is a hayawanun ya'qil. What's the difference between hayawanun aqil and hayawanun ya'qil?
One's the ability to think, the other one can think.
Yeah, but it's not just the ability. Aqil, what kind of word is that?
It's active.
Yeah, it's an ism fa'il, right? So, the ism fa'il man sha'nuhu an yaqil, right? The one whose nature is that they actively think. They are an actively thinking animal. So if you say something, what do you assume about them? That they're thinking. Right? That's how the ulama wrote. That if I don't mention a damir, you will if I don't mention the fi'il or the fa'il, or I don't mention the fi'il, fa'il, or the maf'ul, you're going to figure out. وَلَوْ مَضْمُونًا. What is لَوْ مَضْمُونًا? If you are حيوان عاقل, you will think لو كان العين مضمونا. كان and العين are both not mentioned. They're not mentioned because if you're عاقل, you can figure it out. But addressing the human being in this way, it one, respects them, and number one, ennobles them. And number three, it elevates them. Respects, ennobles, and elevates. Where if you write out everything and simplify everything, you're assuming the human being is a hayawanun yaqil. The human being is an animal that can think. You're not respecting them. You're not ennobling them. And you're not giving the tools of elevation. Now, it's a delicate balance between that and yassiru wa la tu'assiru, make things easy, do not make them hard. But the ulama wrote in this way to bring us up, right? And these sections are an example of that. So we're taking a little bit of time, but some of this is on you. So now this is an example, what we're coming next on. The issue of, this issue coming up of ضمان الدرك. ضمان الدرك بفتحتين is of this type as well. So we'll take that. I'll unpack it for you, but just take a moment And we're going to have a supplementary class. We had a death in the family, so last week was a little bit mushawash in that sense, but we'll tackle that bi'idhnillahi ta'ala. So we'll give a supplementary class to cover that. We'll give a 24 hours to an announcement of doing that. So we'll finish this and finish. So in the supplementary class, inshallah, we'll finish till the end. We're going to give you 24 hours at least, so to complete, to do some solid preparation for this and for hawala, and then we'll get to abwab al-qada, which also illustrate a lot of very important principles of Islam. تماما جزاكم الله تعالى خيرا وصلى الله على سيدنا ونبينا محمد وعلى آله وصحبه وسلم وآخر دعوانا أن الحمد لله رب العالمين.